Welcome to another special edition of the Durst Show. In this edition, I'm going to give advice to the Trump legal team. I've gotten lots and lots of emails, lots of calls. Why don't you join the Trump legal team? As you know, I have a policy. I represent a client only once. I represented Trump once on the floor of the Senate. So I'm not going to become a formal part of his legal team, although obviously there have been those who've requested me to do that. I will, however, give legal advice, but I'll give it through this show. And I know that some of the people on the Trump legal team do watch the show, and they can get my advice just like you can get my advice. I'm not going to give lawyer-client confidential advice in a personal way, at least not at the moment, but I will say what I think, and I'll give the same advice I would give in a confidential way. Of course, the difference is I may not know some things about the case that obviously the lawyers know, and maybe that they're unwilling to share with me. For example, what Trump's own attitude is toward certain things. I'm not in a privileged situation with Trump. I spoke to him, obviously, last Monday when I was at the trial, and I've spoken to him on numerous occasions, but I'm not in a lawyer-client confidential relationship with him. I was, obviously, when I defended him on the floor of the Senate, but I'm not now. So I'm just going to say what I think. And if they want to listen to my advice, they can. Sometimes they have, sometimes they haven't. So let me indicate what I think I would do. I would try to take some unusual steps to speed up the appellate process in this case. Now, as many of you know, particularly those of you who are lawyers, you can't appeal the case until the sentencing. And the judge put off the sentencing for quite a long time, July 11th, I think it is, just a few days before the Republican convention. But there's nothing written in stone about that sentencing date. The judge knows what he's going to sentence the judge to, what he's going to sentence Trump to. He knows it right now. He probably knew it even before there was a conviction, because he knew there'd be a conviction, as virtually everybody else who was watching the trial knew there'd be a conviction. So there's no reason to put the sentencing off until July 11th. If I were Trump's lawyers, I would make a motion to have the sentencing next week as fast as possible. And I would explain that the reason for moving to have the sentence expedited is to get the appeal expedited, because we don't want to delay. We want to get this appeal decided one way or another. Just like the prosecution argued over and over again, we have the right to have this case tried before the election. Well, Trump has the right to have this appeal decided before the election. So I would start by trying to expedite the sentencing. The judge will probably say, no one's above the law. This is the way I do it. This is the way I've always done it. No, this is an unusual case. The man you're sentencing is running for president of the United States. So if the judge refuses to move the sentencing up, I would then skip the appellate division, which is the Intermediate Court of Appeals, which is a Manhattan-based court with judges who are Democrats and with judges who not only clearly voted against Trump, but who have families that will not look kindly upon them if they are perceived as helping Trump become president of the United States. So I don't think there's much of a shot of getting a reversal in the appellate division. Even Harvey Weinstein's case, I listened to some of the argument, and the argument in that case was overwhelmingly against the conviction in the Harvey Weinstein case. There was so many legal errors, but in the end, the court didn't have the courage to reverse Harvey Weinstein's conviction. And so they affirmed unanimously. And then they went up to the New York Court of Appeals, where they reversed the appellate division. So if it were me, if you want my advice, I would try to skip the appellate division. And there's a process for doing that. And I would try to take the case up to the New York Court of Appeals immediately. So let's assume that my schedule operates. Let's assume today is Friday. Sentencing is, say, a week from Monday, 10 days from now. Then I would appeal immediately, file a notice of appeal immediately to the New York Court of Appeals and tell them that we will have the briefs prepared within 2 weeks. So then we're another 2 weeks out, and ask for the government to file its briefs within 2 weeks as well, and try to get argument within a month. So at that point, we're probably at the end of in the middle of July at some point, maybe the end of July, and to hope that the court will come down with a decision. Remember, courts sometimes can decide a case, we reverse the conviction, opinion later, and then they write a short, brief opinion, and then a longer opinion later. But at that point, you can appeal. Let's assume they affirm the conviction, the New York Court of Appeals. They shouldn't, because under the Harvey Weinstein precedent, the two mistakes that resulted in Weinstein's conviction being reversed are the same two mistakes the judges made in this case. Let in too much evidence that was irrelevant and salacious about Donald Trump's alleged relationship with Stormy Daniels. Utterly irrelevant, because it doesn't matter whether Trump did or didn't have sex with Stormy Daniels. That doesn't matter. All that matters is that Stormy Daniels, according to him, tried to extort him and threatened to expose a relationship which either occurred or didn't occur unless money was paid. And you don't have to have had sex to be willing to pay money to prevent allegations of sex from coming out. We know that because there was another accusation made by a doorman in the building in which he claimed that he knew that Donald Trump had fathered a child, and money was paid to him not to disclose that, even though it became very, very clear that the story was utterly untrue. So it matters not at all whether or not Trump had sex or didn't have sex with Stormy Daniels. And so that should never have come in. The judge also threatened and said he would let in other things, McDougal, the Playmate, other bad conduct instances if Trump took the witness stand. And Trump can claim, the way Weinstein claimed, that this imposed the burden on his absolute constitutional right to testify, because if he did testify, that would mean that all this inadmissible evidence can come in. Those were the two grounds on which the Court of Appeals reversed. And I would start my brief in the Court of Appeals with those two grounds, because they're grounds that the Court of Appeals is familiar with. They just reversed the conviction based on that. Then I would move to, some other issues. The expert witness is a very key issue, because the prosecution, in its closing argument, over and over again argued that it was a fact, not law, a fact, that the payments that were made to Stormy Daniels constituted an unlawful campaign contribution. But the great expert, the best expert in the country on federal election law, former member of the commission, was prepared to testify, no, as a matter of fact, that is not a violation of law. Now, the judge said, no, he can't testify because that's law. But the prosecution said it's fact. They can't have it both ways. They can't tell the jury it's a fact and then deny the defense the opportunity to present a fact witness that would dispute that. That seems to me to be a very, very clear error. The other one is the missing witness instruction. The key conversation, the only conversation which, if believed, would meet some of the elements of the crime and get it over the threshold of a directed verdict. The only conversation is one that occurred between Donald Trump, who didn't testify and didn't have to testify, Cohen, who testified and almost certainly lied, and Alan Weisenfeld. I can never get this guy's name straight. I have a block. In any event, and Alan wasn't called. The prosecution could have called him. Maybe he would have taken the fifth, but they could have given him immunity, and he would have to then testify. And they didn't do that. And that should have resulted in an instruction to the jury that you can infer that because the prosecution could have immunized him and called him and didn't, that his testimony would not have corroborated Cohen's account, but would have contradicted it. Would that have made any difference in the case? I don't know. I think this was a foregone conclusion that there was going to be a conviction. But a court of appeals is not going to say that. So a court of appeals may have to say this was prejudicial. It could have had an impact on the verdict of the case. There are other issues as well that can be raised. Due process, fair warning. There's no way anybody thinking about making a non-disclosure payment and then deciding how to list it would imagine that 6 years later they would concoct a felony out of that. There's no way he got fair warning, that he got notice that his activity would constitute a felony. And then there's this, what appears to be a minor point, but could be a possible reversible error. The judge, as you know, kicked everybody out of the courtroom, except for me and a couple of other lawyers, but all the media. And that denied not only Trump a public trial, but it denied the rest of the people who were thrown out of the courtroom a public trial. And there have been cases reversed on that without necessarily showing a prejudice. So I would try to take the case to the Court of Appeals as soon as possible, and you might get a verdict at that point by, middle of August. If the verdict is to affirm the conviction, then you could take the case to the United States Supreme Court, and you would ask the Supreme Court to do what the Supreme Court did in Bush versus Gore and other cases, to expedite consideration, either to waive oral argument or to have oral argument, 2 weeks after getting the briefs. And there's still a possibility the court could decide the case before the election. So if I'm Trump's lawyers, for me, everything is speed, 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 speed. That's a change of attitude, because Trump's lawyers in some of the other cases are seeking delay. Of course, the difference is in those cases there is no conviction, whereas in this case there is a conviction, and that conviction hangs over his head like a sort of Damocles. Now, we don't know whether or not this conviction is going to help or hurt Donald Trump. He's apparently raised fortunes of money in fundraising, including a lot of new donors, as a result of this conviction. I have to tell you something else. Had this trial been on television, and had the public been allowed to see how Judge Marchant manipulated this case and rigged the outcome of the case, in my opinion, I think even more people who are on the fence, people like me, people who have voted Democrat in the past but have open minds, I think a lot of people would have been influenced to cast a protest vote against this proceeding and proceedings like it if it had been on television, but it wasn't. And so what we have is these silos, people who watch the trial through the prism of MSNBC, where the people were dancing in the aisles and screaming up and down, what a great day, what a great victory it is for justice. So, and if you watch it on other channels, you would have a different result. And now the president has weighed in, and the president made a statement today, which I fundamentally disagree with. He said, no, don't say that the justice system or this case was rigged. We have to all support our justice system. No, we don't, Mr. President. No, we don't. Don't tell me how I ought to assess the American legal system. I know the American legal system a lot better than you do, and it's deeply flawed. If I were living in South Carolina in 1940s, I would be obviously condemning the all-white legal system that was imposing Jim Crow. I'm not making analogies here, but I especially have a responsibility to tell the truth about the legal system. I'm not going to listen to you, Mr. President. No. Actually, in this instance, Trump is right and you're wrong. This case was rigged. And I'm going to say it. I'm going to say it over and over again. This case was rigged from the very beginning. And he did not get justice. He did not get a fair shake. He did not get a fair trial. And when you say that the justice system is fair when it's not, you're doing a horrible disservice, especially since we've now reduced our checks and balances. It used to be that juries served as a check and balance on the excesses of prosecutors, the excesses of judges. But when you pick a jury that's as biased and prejudiced as the judge and the prosecutor, you're not getting a check and balance. So where does the check and balance come from? It comes from the public. It comes from academics like me. It comes from honest people in the media. It comes from honest people in other parts of life, in academia. That's the check. That's the check. And I'm not going to eliminate my check by simply saying, yes, sir, Mr. President, I agree with you. You have to respect the legal system. No, the legal system has to earn your respect. And the legal system as it operated in this case in New York does not deserve anyone's respect. It doesn't deserve your respect, President Biden. It certainly doesn't deserve my respect. It's not getting it. No matter what you say, it's not getting it. I'm going to tell the truth. My commitment is to principle and truth and justice, not to the Democratic Party, not to the President of the United States. You know, I love when people say the President of the United States is the commander-in-chief. No, he's not the commander-in-chief of me or you. He's the commander-in-chief of the armed forces. He can't tell us what to do or what to say. In fact, the Supreme Court of the United States just 2 days ago in the NRA case, National Rifle Association case, unanimous decision said the government can't tell you what to think. The government can't punish you for thinking things different from what they think. And the same thing is true for the incumbent president of the United States. He can express his opinion. Fine, he's wrong. He's wrong. And I want to tell you, if you want to listen to me instead of him, do not respect the judicial system as it operated in this case. The prosecutor deserves no respect. The judge deserves no respect. And I hate to say this, but the jurors deserve no respect. They did not stand up for justice. They just went along like lemmings. They listened to the judge. They listened to the prosecutor. They didn't engage in independent thinking about this, and they failed to serve as a check and balance on the excesses of prosecutors and the excesses of the judiciary. So this is a very disappointing day for justice, but we have the right of free speech, and I'm going to maintain my right of free speech, and I'm going to continue to criticize the judiciary. I've criticized the judiciary since I was a young lawyer. In my first book, The Best Defense, I have a chapter called Black Robes, White Lies, in which I went after judges for not telling the truth. In that context, it was about evidence that was illegally seized. But I urged disrespect for the judiciary back in 1982 when the judiciary doesn't deserve our respect. And the judiciary certainly didn't deserve any respect yesterday. Just one more closing point. Part of the problem with the American judicial system is, it's going to sound strange, democracy. President Andrew Jackson introduced what's called Jacksonian democracy. He turned America from a republic into a democracy. And under Jacksonian democracy, you vote for everything. You vote for who the prosecutor is going to be. You vote for who the defense attorneys are going to be. Actually, you do in Florida. You get to vote for who the public defender is. You get to vote for judges. And that we're the only Western democracy in the world that votes for prosecutors and judges in Florida and maybe some other places, public defenders. That's not the right approach. There are areas of democracy. Yes, you should vote for dog catcher. That's okay. You should vote for people in lots of different positions, but not for prosecutors. You don't want prosecutors to worry about re-election. You don't want prosecutors to do what Bragg did in this case. Vote for me and I'll get Trump. No, that's not the proper role of a prosecutor. You don't want judges to be elected. Look what happened in Georgia. The judge who presided and didn't recuse Fani Willis ran for re-election just weeks after making a decision not to recuse her. And I don't know whether he won or lost. I didn't follow it. But that's not the way we should administer justice in this country. Judges and prosecutors should be professionals, and no professional prosecutor would have brought this case, and no professional judge would have allowed it to result in a conviction. So we have a lot of fixing to do. This case is a valuable one because it reveals and discloses so many deep flaws in our system. I'll continue to give advice. You can reject it, you can accept it. You can listen to it or not listen to it. And I hope that the conviction in this case is eventually reversed. And I hope if it's reversed before the election, not because I have a dog in this fight. I haven't made up my mind who I'm going to vote for. I'm traditionally a Democrat, but the Democratic Party is leaving me very quickly. It's not because of the result I want in the election. It's because of the result I want about the Constitution. The Constitution is weaker today than it was yesterday. And it's going to be weaker tomorrow than it is today if we continue down this path. And what we're going to see now is prosecutors from both parties, ambitious partisan prosecutors going after their political opponents and trying to do to them what Bragg did to Trump. Yeah, Bragg got Trump. To paraphrase my book, Get Trump. Bragg got Trump for now. But let's see whether that conviction sticks. Let's see what the implications are for other cases. And let's hope that American justice, which has been a mixed blessing right from the beginning of our constitutional history. Early on, Jefferson went after Aaron Burr. Aaron Burr defended himself and got acquitted. We had other cases in America which have been horrible. The Dred Scott decision, Plessy versus Ferguson, a mixed bag. And then we had some great decisions and controversial decisions like Roe versus Wade. This decision yesterday should not be controversial. Every American who cares about justice, whether you're for Trump or against him, whether you're a Democrat or Republican, a liberal or conservative, should strongly oppose the weaponization of our criminal justice system in a partisan fashion. That's what we saw here. And President Biden, you would do us all a great service if you would look hard at this case and tell us, hey, maybe you should criticize the result. At least you have the right to criticize the result, but don't lecture us and don't tell us that we have to stand up for the judiciary, even when the judiciary is wrong. No, that's not the right approach to justice. We have to have justice. The Bible says justice must you pursue. And it also says to judges, don't recognize faces. And the judge in this case violated biblical principles, constitutional principles, and moral principles. And I'm going to call that out as long as I have the energy to do it. See you next week.